would like to invite Attorney Shannon McNulty. I'm going to say about her some few words. Attorney Shannon McNulty is a founder of Global Village Law, an initiative of the Village Law Firm in New York City. Global Village Law focuses exclusively on the legal planning needs of international families, helping them to protect their loved ones, minimize taxes, and preserve their wealth. McNulty is a host of the Global Village Law and Money podcast, which helps cross border families and individuals make smart legal and financial decisions so that they can build a successful life in the United States. Ms. McNulty graduated from Georgetown University Law Center and received her LLM in taxation from New York's University School of Law. She has also earned the CFP designation from the Certified Financial Planner Board of Standards. Shannon is a currently member of the New York Estate Planning Council and the International Section and Trust and Estate Section of the New York State Bar Association. Please, Shannon.
Thank you so much. So I'm really, it's an honor to be here, and I was really happy because I think that to be able to share so much with you on this topic, because just some stories that I've heard in terms of people having problems and clients who I've dealt with in terms of making sure that their families are taken care of, and both legally and financially, and it can cause a lot of problems if these protections aren't in place in advance. So what I do is ideally I work with clients before there's any issue, and everybody should have these kinds of documents in place. So I work with them to make sure that there are documents in place so that if something happened to them, that their kids would be protected and that the finances would be there to take care of them. Unfortunately, I've dealt with as well people who haven't had those protections in place, and it's caused a lot of problems. So I really am an advocate for making sure that this planning is done. And so I'm really glad that you've chosen to highlight this topic in this for this program. So thank you. I'm going to have a presentation, so I'm going to pull that up. Let's see. Okay. So just a disclaimer, all of this information is just for educational and informational purposes, and you should talk to a lawyer individually for your specific situation. Okay, and this webinar is for you all who are on here, I think, and in this case, most of the clients who I have, they are here in the US on some kind of visa, whether it be H-1B visa, a green card, some have been naturalized. Often they're close family members. They don't have close family members in the US, and those close family members are still in India. Often they own assets in India. So these are the types of clients who I work with, and that they have particular issues when it comes to estate planning. So I think we've already been introduced adequately. Some of the concerns that clients have when they come to me, they want to make sure that they protect their young kids and their children's inheritance if something happened to them. They want to make sure that things are easy on family that's either in the US or abroad. They want to make sure that their wishes are respected in case they became incapacitated. So if they were in the hospital and unconscious, who would be making decisions for them, who would be managing their finances. And finally, making sure we minimize taxes so that there will be more there for their family. So I'm going to go through appointing a guardian. A guardian is someone who is appointed by a court to take care of your kids if you were not able, either because you've passed away or if you're incapacitated. Planning for your kids' inheritance, and then avoiding bureaucratic nightmares for friends and relatives. Talk about how to do that. I'll go over some key documents that you should have in place. And then I'll also talk a little bit about estate taxes and a few tips to make sure that we don't get caught in any tax traps with the IRS. Okay, so first I want to just go over some key terms, because I know this can be completely new to a lot of you, and this isn't something maybe you've dealt with either here in the US or in India. So I just want to explain some terms because they can be confusing if you don't understand them. And a lot of people, even who were born in the US, are not necessarily familiar with these terms. So the first one is a guardian, and this is really the most important, is who would take care of your child if you weren't there to take care of them. And that's a legal term, and that is a legal person who's recognized by the court and in law. Your last will and testament, that's a document that you sign that instructs both who your guardian is and sets forth who will get your assets if you passed away. An executor is the person who is designated, they're named in your will, in your last will and testament, as the person who takes care of everything. So who is managing your affairs, who's making sure that documents are filed with the court, that the assets get to the people who they're supposed to get to. An estate is basically all of your assets after you pass away. Your estate is all of your property, bank accounts, anything like that. Probate and estate administration refers to the court process that oversees the transfer of your assets from you to your loved ones if you should pass away. A trust, so trust can mean I trust you, in that sense. Trust in this case is a type of tool that's used in estate planning for various purposes. And it allows someone to manage the assets in an entity. So it's kind of like a company, but it's just like this legal entity that's managed by the trustee. We'll talk a little bit more about that. But those are like kind of the key terms that it's important to understand. Okay, so guardianship, who would take care of your child if you couldn't? And this is the most important, definitely all of my clients who have children under the age of 18, this is the most important part of estate planning. A lot of people come to me about their taxes or their assets, but really the most important thing for sure is who would be taking care of your child on a day-to-day basis. And the guardian is not just going to be your next family member. It's not necessarily obvious who the guardian would be. The guardian is, so a lot of times my clients think, oh, my family member from my home country can just come to the US and get my child. Like my mom can come and get her grandchild, or my sister can come get her niece or nephew and take them back to India. But that's not how it works. The guardian is somebody who's named in your will. So usually we would, when we're working with clients, we name the guardian, whoever they want to serve in this role in their last will and testament. Importantly, a guardian in most cases must be appointed by a court, must be appointed by a US court. And so even if you name somebody in your will, they don't necessarily have to be approved by the court. The court will impose what's called best interest of the child standard. So they would look to what is in the best interest of the child, and that's who will be appointed as the guardian. The appointment of a foreign guardian can involve a lot of court delays and proceedings. So if you have just a domestic guardian here in the US, if you have somebody here in the US, it's some more of a formality in terms of them being appointed, unless somebody contests it, unless another family member contests it, or close friend or somebody contests it. In most cases, the court is going to just appoint the person who has been designated in your will. However, if the person you designated is a foreign guardian, or if you have not done a will, then the court must, in order for them to appoint a foreign person, that they have to go through a process. That process requires an investigation of the foreign guardian in their home country, and only then will the US court appoint that person, and after they've determined that it's in the best interest of the child to appoint that person. So it's really important, if you do choose a foreign guardian, to make sure that you have an alternate plan, that you have somebody in the US who can take custody of your child during that time when you're waiting for the court to make the appointment of the foreign guardian. So what happens if there's no guardian? So if you haven't appointed anybody in your will, or and your family is abroad, the child can end up in state custody. So they can end up in the foster care system. This can also subject them to being adopted by strangers. So this is like basically any parent's worst nightmare, I think. So that's why it's really, really important to make sure that you have a really good plan in place to designate the guardian, and also to have a backup guardian in the US. So even if the court decides to appoint the foreign guardian, there's always going to be a lag time. And we're talking about, maybe a year that's going to take place. So you want to make sure that there's somebody who's here in the US who can take care of your child during that time. So you don't want your child to end up in state custody. And Nilla will be talking a little bit about child protective services and what that is, but generally, as a rule of thumb, you don't really want your child ending up there. So in terms of what you should do to make sure that this doesn't happen to your child, and your child is always in the care of somebody who you trust, you want to make sure that you designate a guardian in your will. If the guardian lives abroad, then you want to designate a US resident as a backup temporarily, and that should be documented in your will as well. You want to designate a temporary guardian to serve immediately or in case of incapacity. And in different states, that temporary guardianship is done in different ways. I recommend generally, when I work with clients who have a foreign guardian in their will, that we prepare a letter to the court in support of your choice of guardian and why it's so important for that particular person to serve. In addition, you want to notify your chosen guardians and share the documents with them so that they know if something happens to you, what they should do. And you also want to document important information that the guardian might need for your kids. So what are if they have medical issues, allergies, things like that, anything that either the temporary guardian might need or the permanent guardian might need. So that's something that I think, so that's kind of a comprehensive guardianship planning to make sure both the legal documents are in place, but also even as importantly, those kind of practical information is shared so that everything goes how it's supposed to go. People know what they're supposed to do. Okay. The other part of estate planning is making sure that your financial resources are available for your family. So when you pass away, it's not automatic that your spouse gets your assets automatically, or your children get your assets automatically. It depends on how the asset is owned and who it's inherited by, and we'll go through what each of those assets, what those types of assets are, and what the process is for the transfer of those assets. So generally, when you've passed away, all of your assets are frozen until they're transferred to your heirs, and there's particular processes that allow for that to happen. Okay, so jointly owned assets, and this could be a joint bank account or a jointly owned house that the surviving owner would inherit. And then the process is basically just providing a death certificate, and they would get the full bank account, or they automatically would get the full ownership of the house. The process, if a minor inherits, so a minor would only inherit in this case if both of the owners passed away. So if that happens, then what we call a court conservatorship or a court guardianship sometimes is imposed, meaning that the court oversees the management of the asset until the child turns 18. And that can be a pretty not an ideal arrangement. So you do want to make sure that we do planning, and we could talk about how we can arrange that so that that doesn't happen. But if there is a jointly owned asset and both owners survive, and the asset, either if there is no will, it might go to the minor child automatically, or if your will leaves everything to your children directly, it's going to go into this court conservatorship. Assets that have another category is assets with a beneficiary. So these assets, the most common one is life insurance. And in life insurance, we designate a beneficiary of who inherits the life insurance proceeds when we pass away. And other types of assets with the beneficiary are often your retirement account, other financial accounts with a beneficiary, or other kind of beneficiary designations. The person who inherits that is going to be the person who's listed as the beneficiary. And that's a pretty simple process. Generally, you just have to provide the death certificate to the financial institution with proof of your identity. Again, if a minor is listed as a beneficiary, this is going to create a court conservatorship and is going to be stuck in the courts for many years until the child turns 18. All other assets, so those are kind of two assets that go directly to the beneficiary, unless the beneficiary is a child. All other assets have to go through a different process, and that process is called probate or estate administration. That's the court process that allows for the transfer of your assets from you to whoever is inheriting them. So this is all financial accounts that don't have a beneficiary designation, any business interests, any real estate that's owned by you individually. The person who inherits is either whoever you've listed in your will, or if there's no will, whoever is we'll call it your heirs at law, and we'll talk a little bit about how that works. But the process, and this is if a minor inherits, if anybody else inherits in this situation, it goes through the court. And then if it's the ultimate beneficiary is a minor, then it still is goes into that court conservatorship. Okay, so we'll go through the probate and estate administration process. If there is a last will and testament, and I would advise all of you to have a will to make sure that your assets go to who you want them to go to, and that it goes more quickly. The last will and testament, as I mentioned earlier, it designates an executor, and this executor, the executor is the person who's charged with filing the paperwork, hiring the lawyer, making sure everything gets to where it's supposed to be. This executor must file the original will document with the court, so that original paper document that was signed. So it's really important generally, and in New York, that executor must be a US resident, or they can be a New York resident with a foreign person, but a foreign person can't serve solely as the executor. So that can kind of sometimes create issues with international families. Once the executor files the will with the court, then the executor has to wait for the court to issue an order allowing the executor to access your assets. So without that order, the assets are frozen. And so sometimes this can take quite a bit of time, and your assets can be frozen. And this can create a lot of problems for families because they're relying on that money. And if it's frozen, then they can't pay the bills. They can't pay the mortgage. They can't pay childcare expenses. So this can be an issue. And once the executor has access to the assets, the executor will pay the debts and distribute the assets. And like I said, this can involve lengthy delays, complicated court filings, and there can be some limits on involvement by foreign family members. If there is no last will and testament, then a family member, if you have a family member in the US, will file a petition with the court to serve as the executor. And then the assets are distributed pursuant to state law, and each state has its own laws as to who inherits. In New York, for example, half of the assets, if you don't have a will, half of your assets go to your spouse and half of your assets go to your children. And remember, assets that go directly to your children end up in that court conservatorship. So your spouse only actually really has access to 50%, and your children who are minor have the rest of it. And that's basically going to be tied up in court until they turn 18. So I've seen couples in this situation, and it's very incredibly distressing for the surviving spouse. Okay, and this is what I mentioned before, the court conservatorship. How it works is the court appoints an administrator. Sometimes this person is called a conservator or a guardian of the assets until the child turns 18. This conservator may be limited to being a US citizen or resident, so a foreign person may not be able to serve in this capacity to access the assets. And then the conservator may need to petition the court to use the money for the child. So this is, again, not an ideal arrangement. So for my clients, we always want to avoid this, always. But sometimes if you don't do any planning, often this is what's going to happen. Okay, so how can we avoid this? There's definitely a better way that we can arrange things so that your family doesn't end up in all of this mess. For your guardian always is going to have to be approved by the court. So unfortunately, the best we can do is put all of those documents in place and all of the preparations. But for your assets, we actually can avoid court, and we can do that with what's called a revocable living trust. This is a lot like a will, and often we call it a will substitute. And it's because it directs who will get your assets. It's just that it doesn't go through the court, so there's no waiting period. So whoever is the person who's managing the assets, they can have access to the assets pretty much immediately. It also allows a family member who's outside of the US to administer the assets. So that court process of probate and estate administration, there's often limits on foreign family members and what roles they can play. But if you have a revocable living trust, there's your foreign family members can manage that, and they don't have any restrictions on that. Okay. As far as your children's inheritance, we want to leave the assets to a trust for the children. If there's a revocable living trust, the trustee can be a foreign person. If it's, you can go through, sometimes you can also create a children's trust even if you don't have a revocable trust. You can do it in your will, but there's more restrictions on it that way. So for my international clients, I almost always will do a revocable living trust, and then leaving the children's, it would say I leave my assets to my spouse often. And then if my spouse predeceases me, then it goes into the trust for the children. This way there's no court involvement at all. The surviving parent or other family members who you've appointed as the trustee can manage the money, and it protects the money for the kids until they're older. And you could designate a different age than 18. You could designate 25 or 30, depending on what you think would be best for your kids. Okay, and then this is just kind of how it looks, is that during your life, you have this revocable living trust. And then when you pass away, it would go to your spouse. And then if both of you passed away, it goes to the trust for your children. Other things that are important are planning for your incapacity. So if you were in the hospital and unconscious, who would be making decisions for you? Both your medical decisions and also for your financial decisions, who would be taking care of your kids. So this is another area where we want to make sure that we're protected. The power of attorney there's a couple of documents that are important here. A power of attorney that authorizes someone to manage your finances and make legal decisions for you if you were incapacitated. So often we'll appoint the spouse, you'll appoint your spouse and then somebody else, a friend or a family member. But a lot of times people think, oh, my spouse automatically has that right. They could just go to the bank and get money, or they could sign documents for me, but that's not the case. If they don't have this power of attorney, they don't have the authorization to do that, and they have to go to the court and go through quite a long process to get that authorization. Healthcare proxy, also really important, authorizes someone to make medical decisions for you, and you want to make sure that this is in place. We saw a lot of this questions around this during COVID when people were in the hospital and their family couldn't even get to the hospital. So the doctors would have to do this even by phone. But you want to make sure that somebody is able to make those medical decisions for you. And finally, the standby guardian or temporary guardian, making sure that you appoint a temporary guardian if neither you nor your spouse were able to serve if you were both in the hospital. That's all of these documents are important for incapacity planning. So just to recap these important documents, you want to make sure you have a will, a living trust, a power of attorney. And the living trust should include a trust for your kids. Going back to the power of attorney, the healthcare proxy, standby guardianship. And also, if you have assets outside of the US, you want to make sure that you have a separate plan for those assets. So if you have real estate in India, you want to make sure that you have a plan for those assets and that it doesn't conflict with your plan in the US. Because sometimes what we'll do, we'll have documents done in the US, but then a client will do documents in India and they revoke everything that we did in the US. So you want to make sure that you're working with somebody who has familiarity with how all of these things work together and how the unique issues for international families. And then beyond your documents, feel like it's really important, your legal documents alone are not enough. So that's why we always work with clients to make sure that their plan will work in practice. So that requires, I always work with my clients again and putting into place a letter in support of their guardian choice if that guardian is outside of the US, just in case there's any contest. You want to make sure that you have support of why that guardian is important to appoint that guardian. You want to make sure somebody has access to your will and your other documents. And a copy itself will not suffice. They have to have access to the original will. You want to make sure that they have a list of your assets. So if somebody has these documents, but they don't know what assets you have, then what bank accounts you have, what life insurance policies you have, then that's not going to do them a whole lot of good in terms of having those assets to take care of your family. Guardianship instructions, instructions for your guardian on any medical allergy issues, those kinds of things, doctors for your children. 5, I didn't cover this, but life insurance. If you don't have enough assets to cover for your family, if you passed away, you want to make sure that you have life insurance in place. And that's usually, most of my clients, they don't have, some of them do, but most people just don't have enough money to provide for their kids for the next 20 years if something happened to them and their income was gone. So life insurance is really important in that case. And 6, I say, I would recommend that you have in place emergency contact cards. And this is something we do for our clients, is we have emergency contact cards with their information on it. And they're sort of the 2 emergency contact people who, if there was an emergency, somebody could see that in their wallet and they knew who to contact immediately. This is our estate taxes. I'll just say most people don't have to worry about estate taxes. We're going a little bit overboard here. But if you do have substantial assets, if you're living in the US, if you're a permanent resident here or a US citizen, and you have substantial assets, meaning about $6 million, then you want to do some planning maybe to minimize those taxes. And just the value of your estate is your net worth plus any life insurance proceeds. So that's how you want to calculate it. But I think for more people, you want to make sure, if you're not a permanent resident and you're not a US citizen, you can still be subject to estate tax. And I see this much more often, is that the estate tax exemption in this case is only $60,000. So if you have US based assets and you're not a US citizen and you're not a US resident, your family could get hit with really large taxes. And so you want to just be really wary of holding any assets in the US if you're not a US resident or a permanent resident here. So I just want to do that as a heads up, and I will wrap it up. I think I went longer than I was supposed to, but I hope that was helpful, and we can go on to the next presentation. But if you want to reach out to me, there's a lot of information on our website, globalvillagelaw.com, or you can feel free to reach out directly to me.